Good morning, members. All the members are here. I call the meeting to order. First, I'd like to report that on the 23rd of April, after the last meeting, the Secretariat has uploaded information on the electoral website seeking public submissions. We have also informed 18 district councils. We have so far received one submission. Tomorrow is the deadline. We will forward the information received to the administration for reply and to members for reference. On the last meeting, we have completed discussions on policies and started clause by clause. We completed 68 AAB bracket 2 clause 4. Now we will start with 68 AAB bracket 3 of clause 4. The administration has replied to matters raised in a letter from the legal advisor dated the 16th of April. We can discuss the reply when we're doing the clause by clause scrutiny. I ask members to refer to the marked up copy 6 CB bracket 1655 of 2025 bracket 01. To facilitate better understanding, please quote the top page number, say 00 something. I'll now ask the administration to continue with the clause by clause. We are now on new 68 AAB. This is in relation to specified circumstances, authorized institutions requesting information from other AIs, authorized institutions for prevention of prohibited acts. We're now continuing with clause 3. That is, institution A may request information and institution B without having to obtain consent of the identity disclosed information, and that the information has to be shared on a designated platform except with the Hong Kong MA's prior written approval. Under clause 5, subclause 5, it says that in relation to the information requested, it includes information of the identity, account, and transaction that is the subject of the request, and that the information is disclosed for the purpose of this part. Under bracket C, it says that the grounds for institution A to make the request. Information should be given as to how the information furnished will help with the inquiry, Ms. Carmen Khan. So in relation to the designated platform, under the bill, it will be specified. Provisionally, it will be finest, depending on the situation in the future. So is it the case that it will specify that it's finest? So in practice, how does it work? Does it require the consent of the Hong Kong MA? Do we hear from Mr. Chen from the Hong Kong MA? This is our line of thinking. When the bill comes into effect, well, our consent will have to be obtained, and then we designate a platform. Then the platform will operate in accordance with the ordinance for banks to share information. In the future, if there's any development, we will consult the trade. Please continue. Now we move on 68 AAC, which is the new provision. This is in relation to disclosure of information to other authorized institutions for the prevention and detection of crime. Under bracket 1, it says that when an AI received a request for information under 68 AAB, then the AI may disclose information to other AIs upon the request. Apart from the information set out in the request, under A, it says that the information can be more than the information requested. However, it should be limited to the scope specified. That is, there is reason to believe that the additional information disclosed is related to the entity, account, or transaction identified. Under 4 is a different situation. When an AI discloses information without having received a request. However, the AI disclosing the information, is aware that there are activities relating to an entity or associated entity, and that the transaction or the activity is related to any prohibited conduct. The AI believes that the information will assist in the detection or prevention of any prohibited conduct. Also, if the subject entity is aware of the information disclosed, it may harm the inquiry. The disclosure under 68 AAC may only be made on a designated platform unless with prior written approval by the monetary authority. Ms. Carmen Khan. In relation to the disclosure here, it seems that, under 68 AAB bracket 3, there is also mention of disclosure. It says that institution A making a request to institution B. Now AAC bracket 1, there is this disclosure. Bracket 4, there is also another disclosure. That is, the disclosing institution can take the initiative to disclose information without having received a request. So in relation to the 3 provisions I just mentioned, what scenarios do they cater for so that banks will know in actual situation how it operates? But let me try to answer this part. AAB bracket 3. That is, a bank makes the request to another financial institution asking for information of their clients. The request should specify particular information so that the recipient, so that the institution receiving the request knows what kind of information is to be supplied. So this is in relation to information furnished upon a request. 68 AAC bracket 1. This relates to a request made from A to B, then B discloses information requested to A. That is the scenario of 1-to-1. That is, a request is made to another bank, and then Bank B discloses the information. And then and then under bracket 4, Bank A, on its own initiative, disclose information to another AI because Bank A detects, Bank A is aware of some activities that may be involved in prohibited conduct. Well, then I understand. What I ask for is that in actual practice, there is sufficient information to ensure banks to do the right thing. I will make a disclosure again. I serve in one of the AIs. That is a bank. Under AAB bracket 3 is, institution A will ask for particular information. That is information of an entity and the type of information they would like to get. AAC1 refers to what information they would like to get from the other party. Bracket 4. Well, Bank A makes a request. Bank B supplies a reply, and that's in relation to what kind of information is to be supplied. Bracket 4 is that, some activities are detected. So the institution discloses information to perhaps multiple parties. So the bank that detects certain activities will take the initiative to assist in the detection and prevention of prohibited conduct. Let me supplement, just like what we said in the last meeting. AAC4, it is the case that the bank thinks that the entity is really dubious. Prior to submitting a suspected report, the bank takes the initiative to inform other parties. So there should be reasonable belief that the entity, associated entities may be involved in some prohibited conduct. So there must be a reason to believe. It says here is of the opinion. But there is no mention about reasonable belief. Is it the case that you're referring to reasonable belief that the information or the entity or the transaction is involved in a prohibited conduct? That's why there is no need to add the word reasonable belief. I think on the last occasion there was a mention about the judgment made by the Hong Kong about the Monetary Authority. Where are you referring to? A number of places. Well, it says is of the opinion. In some places it says reasonable grounds. Say AAB bracket 2 in the blue bill is 2421. In the English version. Chinese is 2420. Bracket 2, it says institution A is of the view. And then if you turn the page, say 2428, bracket B in the Chinese version, it says will take on its own initiative. It also says in the opinion. But there is a premise that there is reasonable grounds to believe that the entity or associated entity is involved or have been involved with any prohibited conduct. I will first answer, then I'll defer to Trevor. In the actual operation, what we'd like to achieve is to provide sufficient flexibility for banks to take the initiative to make a disclosure. If you if you ask for reasonable grounds, then there are constraints in terms of timing. So AAB, AAC, we have on several occasions consulted the trade, and they have looked into the provisions to see where it should say in the opinion where is a subjective test, where is an objective test. We have had in-depth discussions with the trade, and we have also sought views from the DOJ. Trevor.
Yeah, apologies for going into English. I'll give the interpreters a break going the other way for a moment. There are two types of sharing going on here.
Trevor, would you please closer to the microphone?
Oh, okay. Can you hear me?
Yes.
There are two types of sharing going on here. There's a request-response procedure and an at-the-bank's own initiative procedure. For the request-response procedure, this is at a point where a bank hasn't yet reached the threshold of suspicion. It sees activity that raises questions, and that activity is linked to another bank. So it wants to talk to the other bank, and the two banks share information. It may show that the activity is perfectly innocent, there's nothing to worry about. Or it may lead to a suspicion and filing of a suspicious transaction report to the police. But before the SDR is filed, only the two banks are seeing that information. On the second type of sharing, which would be more likely to be one-to-many rather than bilateral, the first bank, Institution A, has already reached reasonable grounds to believe. It's probably already filed an STR. It may actually have police force or law enforcement intelligence. And at that point, it needs to alert other banks where it can see a nexus or where there may be a nexus. Other banks may have that customer who has now come under suspicion, or there may be transactions going through that involve that customer. And it's a question of alerting them quickly. The reason for the different thresholds is in the first case, you haven't reached suspicion yet, but the bank believes it warrants inquiries. There are questions to answer. In the second case, we've already reached a position of suspicion. An SDR has been filed. There are reasonable grounds to believe that this may be involved in prohibited conduct. And that's the reason for the two different thresholds.
Yeah. Thank you, Trevor, for the explanation. I'd like to further clarify, even in the second case scenario, the threshold can be with or without STR being filed. Is that right? As long as it meets the wording, is the disclosing institution has reasonable grounds to believe, indicate that the entity or associated account or transaction may be or may have been involved in or associated with any prohibited conduct.
Yes.
So it can be, in timing-wise, it can be before or during or even after the SDR having been filed. So it doesn't limit the scenario to SDR having been filed.
That's quite correct.
Is that correct?
Quite correct and a good point. Normally the first bank, Institution A, in the second scenario, in most cases,
Right.
at the moment on finest, in all cases, it's already filed an STR. But there could be cases where a bank further down the line needs to share information quickly because funds are moving very fast through the system and may need to share information
Understood.
before it files an STR. And there is a provision in here that gives the police access to that information because if an STR hasn't been filed under current law, they can't see it. So filing an STR is not a condition of sharing. We've avoided that. The threshold is reasonable grounds to believe.
Okay. 主席啊，
係。
我專登問呢一度。
I asked that because I wanted to be clear that we're talking about two situations. That is, we talk about the scenario for disclosure. That is, there's the taking the initiative and one-on-one and also one-to-many scenario. I'm not referring to that. I just want to say that whether you are the person making the request or you are disclosing, whether you are in AAB or AAC 1 or 4, under those scenarios, the institution making the disclosure should reasonably believe that the entity or associated transactions accounts may already be involved in prohibited conduct. So that's the criterion. Earlier on, when we discussed the policy, colleagues have said that whether we could breach privacy law or disclose clients' information inadvertently. So I just want to make it clear that that won't happen because the disclosing organization needs to have reasonable grounds in the first place. As for the information disclosed, that is B, as I mentioned, the disclosing institution, as long as it is of the opinion that the information helps the institution prevent or detect any prohibited conduct, that should be okay. So I think here we need not add the words reasonable grounds. So because these institutions all along have been actually looking at the situation. So when it comes to the information disclosed, we need not be so concerned about the exact wording. As long as it can help detect and prevent the prohibited conduct, that would be the requirement. As long as the information disclosed is helpful for that purpose, that would be enough. So just to make it clear to the banks that in the future, if there are objective criteria or a situation leading the institution to think that the account could be linked to prohibited conduct, that will be enough. As for the information to be disclosed, I think we can be more flexible in the definition of that. So is my understanding correct? DOJ or who else? Ms. Ken, your understanding is correct. Ms. Ken, your understanding description just now is correct. Just now, we mentioned several scenarios in relation to exchange of information. When it comes to AAD, that is after the initiative has been made, the institution receiving the information, like as mentioned, AAD, if you have the view that the transaction is related to prohibited conduct, we put the threshold there. That is, if the receiving institution has reasonable grounds, then the information can be disclosed. So if there's no objection, Chairman, let's move on to AAD. Mr. Wong, please. 68 AAD lists the conditions and regulations on onward disclosure of information. Bracket 1 states that if an AI has, on the basis of 6 AAC, make disclosure of information, and then the receiving institution, according to bracket 2, may, in the circumstances specified in subsection 3, disclose the information to another authorized institution without having to obtain the consent of any entity to which the information relates. Bracket 3 states that, as Mr. Ho just now mentioned, bracket A, subbracket A, states that the circumstances are that the receiving institution has reasonable grounds to believe that any entity, account, or transaction to which the information relates may be or may have been involved in or associated with any prohibited conduct. And the receiving institution is of the opinion that disclosing the information may assist the further institution in detecting or preventing any prohibited conduct. And also, the receiving institution has reasonable grounds to believe that seeking the consent referred to in subsection 2 would risk prejudicing the further institution's detection or prevention of any prohibited conduct. Bracket 4 states that if the receiving institution want to disclose to others, then it does not authorize the receiving institution to disclose the name of the disclosing institution or any information that may enable the disclosing institution to be identified. And subsection 5 states that disclosure can only be made on a designated platform unless there is written approval by the monetary authority. Before Ms. Ken asks the questions, I just want to ask about the heading for 68AAD is in English, onward disclosure of information. But whether it's in the Chinese or English versions under it, you said disclosure. Even though this is not legally binding. But so why in the heading we use onward disclosure? Why is the word onward there? So what does the DOJ think? Mr. Ho, could you think of a more relevant or exact wording there in the heading? Ms. Wong? Mr. Wong? Thank you, Chairman, for your question. As mentioned by the Chairman, in the drafting process, we consider that the heading has no legal effect. So in drafting, we would look at the Chinese and English text and try to choose the word that most clearly describe what we want to express. Onward disclosure means that when an authorized institution receives information and it wants to, as a middleman, make an onward disclosure. So that's why we wanted to use onward in the heading. Okay, thank you. Ms. Ken? Thank you, Chairman. My first question, also similar to your observation, I wanted to suggest in Chinese 准披露, which is closer to the meaning of the English expression onward disclosure. The English is fine, but in the Chinese version, I think you could consider make it more closer in meaning to the English version. And bracket 4, when the information is further passed on, that is, after you've taken the initiative, the receiving institution thinks that this information may be useful to all, that it can further on disclose it down the line. But of course, we're talking about disclosure on a designated platform, so in finance. So it's not that you just make any call you like. So the mode of disclosure has to be via the designated platform. And secondly, for further disclosure to other institutions, that cannot be done without the prior consent of the disclosing institution. But can you explain to us the rationale of this subsection, Trevor? Trevor, please.
Really envisages a scenario where Bank A has seen something, has reasonable grounds to believe, has alerted Bank B and possibly others, but Bank B finds that the funds, say we have a fraud case and the funds have gone into a number of accounts with Bank A, have then been consolidated and sent to an account of Bank B. So Bank A wants to alert Bank B. But then Bank B finds that the funds have already moved to Bank C. And today, in the days of faster payments, this can happen very, very quickly. So we need a mechanism for the banks to be able to alert each other downstream, down the line. But I think the banks obviously have a concern that information they have provided should not just be sent on without some consent from them. And that seems reasonable. That's why we've included that clause.
明白。
OK，陳助理總裁。
就其實
Mr. Chen, I think this provision comes out of our discussions with banks. As Trevor just mentioned, there is a scenario that Bank B may need to notify Bank C and yet does not want to disclose that the source is from Bank A without Bank A's consent. So we want to see that as information is exchanged, that we need not be worried that after information is sent to Bank B, even though it could disclose it to other banks, but it would not disclose the name. So that the information by Bank A to Bank B, when Bank A discloses the information to Bank B, it can be feel more at ease, not worried. And so this is what we think a better arrangement for the actual operation.
咁樣係
If this reflects the wish for the sector to operate it in a reasonable manner, I think I will find this reasonable. Next, please. 68 AAE, which is a new provision, requires AIs to make corrections of inaccurate information. Under bracket 1, it says that if an AI, having made a disclosure, finds that the information is inaccurate or no longer accurate, then upon such a discovery, then they will have to, as soon as possible, make a correction. Bracket 2 says that if, after having made a correction, the information becomes inaccurate, then as far as practicable, reasonably practicable, another correction has to be made. And the information involves disclosure of information. So this disclosure has to be made on a designated platform. If the original disclosure is covered by a written consent by the monetary authority to do it some other way, then the later disclosure will have to follow the same approach in disclosing the information with the consent of the monetary authority. Mr. Robert Lee. My follow-up question is in relation to page 0012, correction of inaccurate information. It says that the institution, as soon as reasonably practicable, make a correction. So how much time is given to the AI to make the correction? I understand that you will have to make sure that it's time that the correction is made as soon as reasonably practicable. But how much time are we talking about? And if the information remains inaccurate without a correction, what the authority can do as gatekeeping? The disclosure of information has to conform with the requirements and the law. You want to make sure that the information disclosed is accurate and the correction is made as soon as possible. But it requires resources and time. So how long is reasonably practicable? Can the correction be made in phases after several rounds? Let's hear from Mr. Chan from the Hong Kong MA. In relation to the actual operation, you will see in a later provision that the Hong Kong MA will issue a guidelines setting out the details. If an institution is aware that the information supplied is incorrect, I think within 1 or 2 days, a correction should be made. Well, usually you make a disclosure within 1 day. when you become aware of the inaccuracy of the information reasonably, within 1 day you will make the correction. In the future, we'll take into account the operation of the banks to see if it's in compliance with what is set out in the guideline. If it's not in line with what's set out in the guideline, we will make advice. We will give advice to the bank to ask them to speed up the process. If the issue keeps going on, then we will work with the people in charge to follow up. If we detect that it's a deliberate delay, then we will liaise with the management or the board of directors to see if the person in charge is a fit and proper person to handle the matter. My understanding is that there will be details set out in the guideline. There may be a case when someone provides inaccurate information deliberately. Well, I think it's a matter of severity or gravity of the situation. You need to strike a balance. Someone may want to supply the information or make the correction as soon as possible, but the accuracy may be sacrificed for speed. And if the person furnish supplementary information afterwards, then may be okay, unless it's a deliberate act. If it's not a deliberate act to furnish incorrect information, then perhaps the party may be allowed to furnish further information by batches. Mr. Chan? Well, we have discussed this with banks. If you wait till the information is 100% correct before you disclose the information, then you've missed the golden opportunity, the window, the precious window of taking action. We will set it out clearly in the guideline, having consulted the trade. When we have built experience, when it's put into practice, we will try to do our best when it comes to striking a balance between accuracy and efficiency. I would like to hear something from Mr. Chen. Correction of inaccurate information. But what about furnishing further information? Say 10 pieces of information were sought, but 9 have been furnished. The remaining 1, can it be furnished any time afterwards? Raymond? Trevor?
Questions there, Chairman. On further information, yes, of course. If there's been a request or if a bank becomes aware of further information that it has reasonable grounds to believe and it reaches the threshold, it can supply that information any time on the platform. On correction of incorrect information, I think it's worth noting it was the banking sector that asked for this provision. It's a concern of theirs. Not just in how quickly they have to correct information, and I think they have an incentive to correcting any information that turns out to be inaccurate as quickly as they can. Their concern is also that they may have received inaccurate information. Bank A may have inadvertently provided information that is inaccurate, and Bank B is then acting on that information. So it wants to be informed as quickly as possible. With the best will in the world, inaccurate information may get into the system, although banks will take every precaution to avoid that. But where it does happen, there needs to be a mechanism for correcting it as quickly as possible.
OK，唔該晒。咁簡慧敏議員。
Ms. Gamin Khan? I thank Mr. Lee and the chairperson for raising the point. There needs to be a balance between accuracy and speed, because the purpose is to prevent or detect prohibited conduct. Sometimes when we try to stop a crime, the capital has already moved on. Trevor mentioned about downstream banks. We may not be able to catch up, so we have to strike a balance between accuracy and speed. We need to give room to banks so that they don't have to verify the information 100% before making the disclosure, because by then the capital has already disappeared. There is another thing though, safe protection of banks. Making a correction is an obligation when an institution is aware that there is incorrect information furnished or the information disclosed becomes inaccurate. Do we need to protect the bank from being held liable? That is, they should not be held liable for furnishing information that becomes inaccurate. If the information disclosed by the bank comes from another institution, and the information received at the time when it was received was already inaccurate and they were not aware of it, then you need to stop the bank from being held liable. Trevor?
The safe harbour will cover them, provided they have acted with reasonable care and in good faith. An honest mistake they will not be liable for, provided, again, once they become aware that there's inaccurate information, they've taken reasonable steps to correct it. So
Yeah,
they
but-
are covered.
Yeah, my concern is that what you have just said is not exactly incorporated into the wording of the legislation. So I would have fought for better protection to the bank in terms of, not ensuring 100% accuracy of the information. We may consider having some sort of, extension of the safe harbor to give an exemption of liability if, incorporating what you have just said. If the bank, if the authorized institution reasonably believe blah blah blah.
Okay.
唔知各方會唔會考慮下？即係
Will the administration consider that? You now require institutions to make a correction. It's a duty. But without saying that they are exempted from liability, from the accuracy, from being held liable for the accuracy of the information as long as they reasonably believe that the information was accurate. But the information received may not be covered by a guarantee that is accuracy. However, the bank has the duty to make a correction. But there is no mention about the bank not having to be held liable for loss caused by the inaccurate information. Let's hear from Mr. Chen. I think there are two parts to Ms. Kan's question. First, the information knows that the information is inaccurate. Say the information prepared was inaccurate. But if they are aware that the information is inaccurate, it's the duty of the bank to make a correction as soon as reasonably practicable. I think this is appropriate. Banks have looked at the provisions and found them acceptable. And there is another situation. A disclosure had been made. At that time when the disclosure was made, I knew the information was correct. Then there is a safe harbor provision that is still in existence to protect banks. If the bank is aware that the information is incorrect, but it's nothing to do with the bank itself, and the bank is of the view that, well, there is no duty for me to make a correction as soon as possible, then it will then it will undermine the operation of the system. Banks are aware of the provisions we have proposed. They found them acceptable. Banks have the duty to make a correction as soon as possible. But it's not the case that if they furnish incorrect information, then they will lose the safe harbor protection. Does it mean that as long as they have complied with the disclosure requirements under A, B, C, then these are reasonable steps? And if they are of the view that the information will help. However, the information is incorrect or becomes incorrect, as long as the bank takes the action to make a correction, that's fine. The bank is not to be held liable for furnishing information that's incorrect. They will not have lost the safe harbor provision because the information itself is incorrect at one point. The safe harbor provision has been implied. Is that right? Well, we will further explain when we go to the safe harbor provisions. You will see the details that AAB, AAC, how it interacts with the safe harbor provisions.
處長繼續。
Mr. Wong, please continue. 68AF sets out the sharing of information confidentiality requirements. Bracket 1 states that unless required or permitted by law or when ordered by a court, an authorized institution must not disclose the fact that the authorized institution has disclosed information concerned. And bracket 2 states that subsection 1 does not prohibit the fact from being disclosed to the following parties. They are A JFIU officer, B, the monetary authority, or C, a designated platform operator. Section 3 states that an authorized institution, once receiving an information, may only, as stated in subbracket A, may only disclose information as required or permitted by law or when ordered by a court, and may only otherwise use information for detecting or preventing any prohibited conduct. I have a question here. In subsection 2, it states that A JFIU officer. In Chinese, it doesn't state a number, but in English version is a singular noun, and the also singular noun also used for designated platform operator, a designated. So why do you have to use a singular number there? Because later on 68AAJ, when it comes to staff of JFIU, use a officers there, JFIU officers there. So why is there a singular noun here for the two subsections here? Mr. Ho? Ms. Ho, yes. Yeah, you're very meticulous. In Hong Kong's law, it states that for any singular noun or sentence can also refer to a plural representation. And in 68 AAF, subsection 2, and A and C in English version, we use A. Actually, that already refers to all JFIU officers and all operators. So the word A there is a replacement of any. So as the chairman mentioned, why in 68AJ the headline use the plural noun officers? Because in the that's the uniqueness of Hong Kong's or the style of Hong Kong's law drafting in the headline. In the headline, normally we use the plural noun. Please refer to in other clauses we use the plural noun as well, like 68 AAC. The headline is also using a plural noun, say other authorized institutions instead of an other authorized institution. So that's the unique style for the English headline in the English version. So my other question is 68AA bracket E. It allow one JFU officer to transfer information to another officer. So I think subsection 2 is not needed. You may answer me when we come to those AI section, but you think that plural or singular nouns are interchangeable? Then in J bracket 2, so there's no need for that wording. I don't think that in a piece of legislation we should not allow one institution to transfer information, as stated in this section. So if I were to transfer information to Trevor, do I need to make specific provision for that? So, well, as you said, this is your style for legal drafting, then I will have no further comment on that. Ms. Ken, I want to ask about 3B. In Chinese, it says 只可為政策，防止任何受禁行為，以其他方式使用該資料。In English, it says may only otherwise. Otherwise. Why is it that you use the word otherwise here? Subsection 3 is talking about the conditions under which information can be disclosed and how the information can be used. So why the word otherwise there? Ms. Ho? I think this is in relation to the common law. The word use includes disclose as well. In the personal privacy data ordinance, use is defined as including disclosing information to the third party. Therefore, 3A states under what circumstances can the information be disclosed, and in subsection B it deals with, that is, besides disclosure, the authorized institutions, how they can use the information, that is, whether they use it internally. And this is in response to members' concern previously. That is, when an authorized institution obtains an information, whether it can be used for purposes unrelated to detecting or preventing any prohibited conduct. You may imagine, for example, using information for a marketing purpose, but that's not allowed under the current provisions, because here it says that it can only be used, the information can only be used for detecting or preventing any prohibited conduct. Okay, understand. So that this section covers use of the information within the bank. For example, use of information by compliance, auditing, departments. Okay, so thank you. I think you've answered my question. And you've also covered the opinion given by the Privacy Commissioner for personal data. Okay, next one, 68AAG is about the safe harbor provisions for any disclosure made. The institution concerned can be exempted from liability. That is, as we discussed before, the if the conditions are met for making disclosure, then the disclosure is not to be treated as a breach of any restriction on disclosure of information imposed by any contract and so forth, and does not render the authorized institution that made the disclosure liable in damages for any loss arising out of the disclosure. And in subsection 2, conditions are stated that for, like in subsection A, as related to a question raised by Ms. Kent earlier, that the authorized institution that made the disclosure must have acted in good faith and with reasonable care in making the disclosure. And in subsection B, the authorized institution complies with section 68A F (1) in relation to the disclosure. And bracket 3 also offers exemption in that a disclosure does not constitute an offense under the following 3 conditions. That is, drug trafficking ordinance, organized and serious crimes ordinance, or the United Nations anti-terrorism measures ordinance. Mr. Tam. Thank you, Chairman. This safe harbor provisions, bracket 2, about the conditions that the it says that the authorized institution made the disclosure, acted in good faith and with reasonable care in making the disclosure. Reasonable care, good faith, these words. But it's very difficult to define whether someone acted in good faith. And do you have any guidelines to list out some past case? What do you mean by good faith, reasonable care? What are your plan or your arrangements in relation to this? So, explanations of these words. Who can answer? Ms. Ho? Thank you, Mr. Tam, for your question. Reasonable care, that's the English version. In all the under the common law system in Hong Kong, it has a long history of case law, which explains under, for example, in the case of an institution, when using or disclosing an information, what sort of caution should be exercised. I'm sure there's case law available, even though I can't cite an actual case offhand right now, but there is case law for this, in relation to this. And as for acting in good faith, I want to explain to members that in terms of acting in good faith and with reasonable care, this provision is actually, this choice of words are consistent with similar laws in other jurisdictions. For example, in Singapore, the 223 legal amendment in Singapore, and although Section 28I also used the same threshold with the provision on acting in good faith and with reasonable care. In the 2017 financial crime law in UK, similar criteria was adopted. So in drafting this provision, the draftsman agreed that, and the Bureau thinks that this is a feasible standard or threshold. Okay, no follow-up, please continue. Division 3, access to designated platform and duty to keep records and information. Under it is 68AH and 68AAI. 68AH, the headline is access to designated platforms by authorized institutions. And also under this 68AH, Section 1 states that the monetary authority may give a written approval for an authorized institution to access a designated platform for the purpose of this part if the monetary authority is satisfied that the authorized institution has adequate systems of control for ensuring the authorized institution's compliance with requirements. And Bracket 2 states that an authorized institution may only access the designated platform for the purpose of this part if the monetary authority's approval for doing so is in force.
議員。
Please pause there, Mr. Robert Lee. I would like to go back a bit. 68AAI 2, bracket 2. That is keeping a record of at least 5 years. Well, for AIs, some of them keep records for a longer period, some shorter. It says here that if necessary, the monetary authority may require a period that is longer than 5 years. If there is a need, of course, it has to be done, but it won't be more than necessary. Well, how do you draw this line of 5 years? Well, you need to make sure that it is reasonably long, but it won't be excessively long. Hong Kong MA, Mr. Chen. I will first answer. Maybe Trevor will supplement. The legal advisor has asked a similar question. How do we draw the line at 5 years? Information disclosed on the designated platform will mostly overlap with information requested. And when it comes to keeping of records in the banking sector, is 5 years, slightly shorter than other requirements that are 7 years. 5 years is the minimum period in international practice. We think that, well, the 5 years set down in the anti-money laundering ordinance is a suitable timeline. That's why we have chosen 5 years in line with the anti-money laundering ordinance. In the consultation, we have repeatedly asked the trade. The proposed period of retention, is it in line with their operation? They said that it is. In some situation, they may need to keep the information longer. Say, for example, suspicious transaction report. This is to protect the institutions themselves because they have filed the report to meet the statutory requirement. Banks think that it is in line with their actual operation. Mr. Lee, can I ask for further information? It says in division in part 3 that if necessary, it may be longer than 5 years. Well, are there measures to ensure that it will not be longer than necessary? Because it doesn't say how long it is if it's longer. What more can you do to assure the sector that it won't be longer than necessary? Mr. Chen? We will clarify in the guideline. Our intention is to apply it only in necessary scenarios. Say, for example, to assist law enforcement agencies. We will not require institutions to keep the record for a longer time just for any purpose. Well, if keeping it for 5 years may not be sufficient as there is an ongoing law enforcement investigation or prosecution. If it's necessary to keep the information longer, we will make such a requirement. It's not across the board that information should be kept long for 7 years. I understand. If it's limited to certain situations, say for example, need for law enforcement action, that I understand. The way it's written now is rather wide in scope. As long as institutions are not required to keep more information than necessary, then there won't be undue pressure. We will clarify and set out in details in the guideline. Yes. Next, Mr. Tan Yue Hang. I would like to ask about the use of a word 68AAI, the Chinese word of record. One of the characters uses a certain radical. In another clause, it's a different radical in one of the words that means record. I think we will need to hear from the DOJ. Mr. Wong? Thank you. When we pick the word for record, if it's a noun, we use one radical. And if it is a verb, then we use a different radical. We will see if we need to amend it. So it's a difference between a verb and a noun. 68AAI. Any questions? No? Then we move on. Now we move on to Division 4, Miscellaneous Provisions. New, which is a new one. There are 4 new provisions from 68AAJ to M. These deal with miscellaneous issues in relation to the sharing of information. J. Access to information by JFIU officers and designated platform operators. Bracket 1. A JFIU officer may access any information disclosed under 68AAC bracket 4, disclosure on its own initiative, and D, that is onward disclosure, or in relation to making corrections under AAE and other provisions. Bracket 2, it says it's in relation to official secrecy. That is, under subsection 1, are JFIU officers for detecting or preventing any prohibited conduct disclose information to another JFIU officer. Bracket 3 says that the monetary authority may impose conditions on the use of information shared on the designated platform. So perhaps we hear from the DOJ about the necessity of the provisions. Bracket 2, at the outstart, it says, despite Section 120, which is Section 120 of the Banking Ordinance, it's in relation to official secrecy. It says that, well, safe and accepts the necessity to implement the ordinance. Information obtained should be kept confidential or secret. In bracket 2A, it says that this official secrecy applies to public officers as well. JFIU officers are public officers, so the official secrecy provision applies to them. In 68AAF, bracket 2, it states that disclosure may be made to JFIU officer. It relates to an individual officer, not to the joint, not the joint unit itself. So there is a difference here. If it is disclosure to monetary authority under the definition of the law, it means a disclosure to the entire authority or officers delegated by the authority. But since it's already stated that it is a disclosure to individual JFIU officer, and these officers are included under the official secrecy provision. That's why we need to add bracket 2 under 68AA(j) so that these public officers are for detecting or preventing prohibited conduct are allowed to disclose information relating to personal particulars to another officer without being bound by the official secrecy provision. If there is this provision, then 68AA(j), the heading should be changed. Well, you said that the JFIU officers equals to the singular and the operators equals to the applies to singular as well. Then my suggestion is that under this heading, it may be better to use singular form, because under bracket 2 and 3, they are singular. I think, well, if you change it, it will be more consistent. That's for your consideration. Mr. Tan Yue Hang. It says despite section 120. I have looked. I've done some research. There are references of different sections and subsections, but it always states the section or subsection of what. Here, it doesn't say section 120 of what. I heard that it is just section 120. Should an addition be made so that members of the public will know section 120 of what? Perhaps I'll defer to the DOJ to supplement after I've spoken. We are amending the banking ordinance. So all those proposed provisions are to be added to the banking ordinance. That's why, without having made the reference, they all refer to the banking ordinance. There is no need to specify. Ms. Carmen Can. I want to ask a question about bracket 3. It says that the monetary authority may impose conditions. A designated platform operator may access information disclosed on the platform. Currently, there is no designated platform yet. It may be using finance. That means the operator will be the police. Do we need to have a guideline, or is just like AAH that authorized institutions, if they want to have access to the designated platform, should put in place a sufficient control and safeguard? So, well, who can access the information on the platform from the operators? What level are these officers? If it is set out properly, if there is a sufficient control, systems of control, then it will assure members of the public. Mr. Chen. 68 AAJ bracket 3. When a platform is designated for information sharing, the platform has to meet certain standards in terms of data security, access to information. There are limitations. You will have to be a specified officer. Under most circumstances, we think that you assist the operation of the platform. You don't have to access the information. So there are requirements. Well, when we have designated a platform, then we can impose conditions. What we have in mind is just a handful of platforms that are to be designated. We will clarify the agreements and the terms with the operator. If they can meet these requirements, then they will be able to operate, and we will monitor compliance. We think there is a need to impose these conditions. If it's necessary to elaborate in the guideline, we will do so. Okay. AAH talks about the operators that have access. Well, there will be 10. The monetary authority needs to give a written approval before they can join. Is that right? What's your plan?
Ms. Ken is correct. We expect that once the law comes into effect, the relevant institution needs to make a request to access the platform, and they will give them a written approval. And this actually is what we are going to do before the law comes into effect. Please continue. 68 AAK about data access requests in relation to disclosed information for the purpose of Section 23 EA of the Personal Data Privacy Ordinance. An authorized institution, monetary authority, a JFRU officer or designated platform operator is entitled not to comply with the data access request. For your information, the Privacy Ordinance 20(b), the information users has the right not to comply with the relevant request. 68 AAL, the monetary may issue guidelines and give directions. That is issued, or it may issue guidelines relating to any matter under this part by notice published in the Gazette or in another way that the monetary authority considers appropriate. And it would not be a subsidiary legislation. And if the monetary authority considers it necessary for ensuring compliance with this part, the monetary authority may give a written direction to an authorized institution directing it to take an action or refrain from taking an action. Okay, let's stop here. Ms. Ken, I want to ask about bracket 2. Based on bracket 1, that is the notice issued by the monetary authority may not be a subsidiary legislation. Does it apply to the entire banking ordinance? We are making an amendment to the banking ordinance now, but for the guideline issued by the monetary authority is not something new. And issuing guidelines through the publication of a notice, is it common for it to be not considered a subsidiary legislation? Yes, under the banking ordinance, we already are empowered to issue guidelines, including Section 73 or relevant other sections. So, and they are not subsidiary legislations. So this is not a new provision. Yeah, our legal advisor has already asked the same question and got a written reply already. 68 AAM, designation of platforms. The Monetary Authority may, by notice published in the Gazette, designate a platform. And subsection 2, the Monetary Authority must, in a notice under subsection 1, identify the operator of the designated platform. And bracket 3 states that the notice is not a subsidiary legislation. Any questions here? If not, then we have finished the vetting of the Chinese version of the bill. So, legal advisor, can you confirm with us where the English version is appropriate? Yes, the English version of the bill is appropriate. Mr. Chen, Ms. Ken, and other colleagues have asked about the amendment of this ordinance. How does it actually interface or articulate with the privacy personal data privacy ordinance? Maybe I'll ask Trevor to explain to us our communication with the Privacy Commissioner for Personal Data and how this amendment bill actually complements or is consistent with the privacy ordinance. Trevor, please.
Thank you. We've had a lot of discussion with the Privacy Commission over the last 2 years on this. There is a provision in the PDPO, Section 58.2, which exempts data from certain provisions of that ordinance where it is disclosed for the purposes of detecting and preventing crime. And we have followed that wording very consciously in the drafting of this bill. Under Section 60B of that ordinance, the PDPO, data is exempted from Data Protection Principle 3, which is disclosure, use. Where disclosure is authorised by law, and that will be covered, assuming this bill is enacted. Obviously, this will be an authorisation by law. We're not disapplying the PDPO, but there are certain exemptions already built into the PDPO which will cover what we're doing here. One question that was asked earlier about record keeping and making sure that records are not kept for longer than they need to. It is clear from our discussions with the Privacy Commission, Data Protection Principle 2, which is retention of data, continues to apply. So we will remind the banks in the guideline that we will issue of the need to make sure that they're not retaining data for longer than is necessary, something they should already be doing, but we'll remind them that applies here as well.
DPP.
Yeah,
yes,
on data access requests, and this was something that the Privacy Commission actually reminded us about, Section 18 of the PDPO covers a right to a data subject to have access to any data that's held about them. We looked at disapplying that whole part. It's actually Part 5 of the ordinance, but that would mean taking away that right, which didn't make sense and would be very difficult to do. But as Mr. Wong said, Section 20EA provides that you don't have to comply with a data access request where disclosure of the data is authorised by law. So that would also cover this. So we've tied in this bill with the PDPO wherever required, and the Privacy Commission have seen the blue and have confirmed that they're content with it.
好，咁就話 Mr. Trevor Clean 嘅補。
Thank you for supplements from Mr. Keane. Any follow-up questions? If not, the Bills Committee has finished the scrutiny of the bill. So I'd like to ask you, on this bill, any amendment, any motion for amendments? No? Okay, if not, then as according to normal practice, the Secretariat will issue a notice requesting from you whether you want to move any amendment. If yes, the administration will provide written replies and also some follow-up issues today. That is, we'll ask the administration to give us some replies, which will be circulated to members for your consideration. So if you think there's a need for another meeting after going through the replies, then we'll have another meeting. If you don't have any questions, then we may not need to call a third meeting. The administration will confirm later the date for the resumption of second reading. So we don't know the actual date yet. And the other business, Mr. Ho, Deputy Secretary, thank you, members, for scrutinizing the bill. I just want to report on a few things. As mentioned by the chairman, the Secretariat has received some public opinions. One opinion received so far. Tomorrow is the deadline for submission. So after we've collected all comments, we will provide a reply. And we will also go back and carefully look at the text of the bill and see whether there need to be any changes to individual wordings. As Mr. Tan mentioned, Section 68AI, the word in the Chinese version in relation to record where there needs to be a change. And 68AJ, Chairman, you raised questions about the heading. We also discussed with the DOJ on your viewpoints and on the Chairman's suggestion and see whether it can be adjustment in relation to our drafting convention. We look at the whole bill again. If there's any amendment, we will inform the Secretariat. We hope that, even though we have not decided on the exact day, but we hope that maybe by the end of May, early June, we can have resumption of second reading. Thank you. So if there's no AOB, meeting adjourned. Thank you all for coming. Thank you.